So Vybz Kartel has bought a new house. He's bought a new car. He's all over social media. The sightings of Kartel go on and on and on. But why exactly is he free? The Jamaican Court of Appeal has just handed down a 70-page ruling explaining why they freed him. I've read it. I'll be walking you through it. So stay tuned. I'm Dionne Jackson Miller. Thank you so much for joining me. So quick recap for people living on another planet. One of Jamaica's biggest dancehall stars, Vybz Kartel, whose given name is Adidja Palmer, he was arrested in 2011 for the murder of a man called Clive Williams, whose nickname was Lizard. Now 3 others were convicted along with Kartel by a Supreme Court jury in 2014. Their appeals were rejected by the Jamaican Court of Appeal in 2020. Then their convictions were overturned by the UK-based Privy Council in March 2024, 10 years after their conviction. The Privy Council then sent the matter back to the Jamaican Court of Appeal for them to make a decision as to whether the men should be retried for murder or should be freed. And the Court of Appeal freed them on July 31, 2024. Now, I have a whole playlist on the Kartel case. You can catch up there. It includes top 10 moments in the case that will give you a really good overview of what has happened, as well as a video on the jury issues, which led to this whole thing. So you can check those out. I'll link them below. I'll also link them at the end of the video. All right. Now, this 70-page ruling was a unanimous ruling of the 3 judges who heard the arguments as to whether the men should be retried or freed. Now, the starting point in all of this is that there is a rule in the Constitution that says a person should not be tried twice for the same offense unless it has been ordered by a superior court in an appellate process. So if you appeal the matter, if you appeal a conviction, an appellate court can make an order that you can be retried for the same offense. So as I mentioned, it was up to the Court of Appeal to decide if Kartel and the others should be retried, and the Court of Appeal said no. So what the law says is that the Court of Appeal can order a new trial only if the interests of justice so require. So when the interests of justice don't require a new trial, the court must direct that a judgment and a verdict of acquittal be entered against the people involved. The law, though, didn't say what the court should look at in deciding whether or not the interest of justice say that there should be a retrial or not. So over the years, the courts have laid down a list of factors that they look at in making that determination. And there was a 1978 Privy Council case called Reed, which laid down some of those factors that the court has to look at. And these include the seriousness of the offense, the prevalence of the offense, how common it is. Also, if the trial, the first trial, was long and complex, what would be the expense and time involved in a new hearing? What would be the effect of a new trial on the accused? What's the length of time between the alleged date of the commission of the offense and a new trial? And also, what would be the evidence available at the new trial? And also, what is the strength of the prosecution's case presented at the first trial? The court, though, can look at other factors as well. And in the Kartel case, the defense lawyers put additional factors before the court and asked the court to look at them. These included, was there some kind of error or fault or misconduct on the part of the prosecution? Had the appellant served a significant part or all of the sentence that had been imposed at the first trial? What was the impact of publicity? Was there any legal change that would be unfair to the men involved? Would a new trial be oppressive or unjust? All right, so the court looked at all of those factors and let's see what they decided. Let's start with the issue of the seriousness of the offense. Well, that goes without question. We're talking about a murder case, and this is what the court said. They said we consider that the killing of the deceased, that's Lizard Williams, emanated from transactions relating to illegal firearms. The body of the deceased has not been recovered. The crime scene was interfered with while it was under the control of the police. The features of this case bear every hallmark of a deliberate attack on and barefaced defiance of law and order. They said the egregious nature and seriousness of the offense is beyond argument. So too is the prevalence of the offense of murder in Jamaica. So put one ticky in the column in favor of a new trial, seriousness of the offense. Then now, what about the strength of the prosecution's case during the first trial? And the court said that they were satisfied that if the prosecution presented the same evidence in a new trial, each of the men would have a case to answer. They said there is nothing conclusive suggesting that if a new trial were ordered and the prosecution brought forward the same evidence, that a conviction would be improbable, unsafe, or unsatisfactory. In other words, they're saying the evidence against the men from the first trial was strong enough to justify the case having gone to trial, and that you couldn't say that a jury hearing the same evidence would not convict. In addition, the court said that the Privy Council didn't make any finding in relation to weaknesses in the prosecution's case, and there wasn't any legal argument that would undermine the prosecution's case as it was presented at trial. So the court was saying they were satisfied that based on the strength of the prosecution's case at the first trial, that this was a factor in favor of ordering a new trial. So another ticky now goes in the column in favor of a new trial. Let's look now at the availability of the prosecution's witnesses and exhibits. And I can tell you, having sat through the hearing, that the judges had raised a lot of concerns about this. Now, the court quoted from an affidavit, that's written evidence that had been sent in by senior prosecutor Jeremy Taylor, that said the Office of Director of Prosecutions would be able to have his witnesses available for court. And he said that he had made checks and he had caused checks to be made in relation to the availability of witnesses and that most were available. The court wasn't satisfied though. They said that that evidence that the witnesses were available was qualified by the following sentence or the following comment in relation to not all the witnesses being available. And they said that calls into question if indeed the prosecution witnesses would be available for a new trial without delay. They also said the affidavit didn't indicate how Mr. Taylor carried out his checks, what were the nature of the checks, how he caused checks to be carried out, who carried out those checks. They said there was no indication who the available and the unavailable witnesses were. They said, in short, the affidavit was inadequate and couldn't properly assist the court in this issue of whether witnesses were available. Now, the prosecution during the hearing in court had referred to a document, had referred the judges to a document. At the time, we didn't know what that was. Well, it turns out it was a list of 21 witnesses that said 6 of them were unavailable or that their availability hadn't been confirmed. The court said, although a particular provision of the Evidence Act, called Section 31D, could be used to allow statements from missing witnesses to come into evidence, that wasn't enough because there was no indication what was the source of the information that that list of witnesses was compiled from, when it was compiled, and who had done the checks. They also said the affidavit from Mr. Taylor didn't cross-reference the list and didn't attempt to verify the list. The court said there was simply no correlation between the list of witnesses and Mr. Taylor's affidavit. They said the onus is on the Crown, the prosecution, to satisfy the court in advocating for a new trial after more than a decade. They need to show the court that they had made good faith efforts to locate and consult with their witnesses regarding availability. They said it's difficult for the court to send back, remit, a case of this length, complexity, and vintage meaning age, without them having a clear and compelling review of the status of the prosecution witnesses. They said, unfortunately, the Crown, meaning the prosecution, had not established the proper foundation for the court to readily and comfortably accept their contention that the witnesses were available, willing, and able to testify. Then there was a problem of the exhibits. 14 of the 25 exhibits that had been used in the first trial have been accounted for. But the court said no explanation was given for those which had not been accounted for, and which included critical evidence contained in video recordings, voice notes, and defense exhibits. So in short, the prosecution couldn't satisfy the court that its witnesses would be available for a second trial, and it also couldn't satisfy the court that some of the critical and important exhibits which were available at the first trial would be available for a retrial. And I have to say, this certainly would have been a really important point in the judge's decisions. What the court said is that the unsatisfactory explanation regarding the availability of the Crown's witnesses and critical trial exhibits strongly militates against ordering a new trial. So we now have a ticky in the column that says no new trial. I continue to say, it's one thing having difficulty locating witnesses, right? People die, people migrate, sometimes people don't want to be found, don't want to be involved in a second trial. But the issue of the missing exhibits is not something that has been explained. These are critical exhibits from the first trial that were supposed to be in the custody of the state, and then just go missing and nothing. We've heard no explanation. We don't know if there's been an investigation. Has there been some kind of inquiry, internal disciplinary processes? We've heard nothing. And that is really not okay. The country needs to be told what happened here, because this is a fundamental aspect of justice in terms of what is happening to material in the custody of the state. All right, then there's the issue of defense witnesses, the availability of defense witnesses and any evidence that the defense would rely on. Now, there was a letter supposedly written by the main eyewitness, Lamar Chow, to the public defender that the defense relied on that couldn't be found. In that letter, Chow supposedly said that he did not go to the police willingly and that he had seen Lizard Williams after the date on which Lizard was supposed to have been killed. So Chow's signature on that letter now had been ratified, had been verified by a handwriting expert. Problem is, the handwriting expert is now dead and the letter can't be found. So the court said, using the Evidence Act, again, that particular section, that special section 31D that allows statements, paper statements to be used in evidence instead of having the live witnesses. And that would allow the evidence that the handwriting expert gave at the first trial to be now brought into the second trial. That could be used. The problem, though, is that it would create a disadvantage for the defense. They wouldn't be able to cross-examine. There's nobody to cross-examine. The expert is dead. The jury wouldn't be able to assess the expert and to see whether or not they think he's telling the truth. The court said they were satisfied that the unavailability of SSP Carl Major, that's the handwriting expert, as well as the unavailability of the original letter purportedly written by Chow, is a powerful factor against ordering a new trial. Then you have the issue now of time, cost, and expense of a new trial. Remember, this was a trial, 64 days, 30 witnesses, one of the longest and most complex in Jamaican history. And the court said the cost of that first trial must have been staggering. The court said they cannot overlook the significant impact that the matter has had on the resources of the state and the appellants. And they can't ignore the likely adverse impact it will continue to have on our scarce resources and the overall administration of justice, with the staggering backlog of cases if a new trial is ordered. So the court is saying here that the time, cost, and expense of a new trial are factors which are going to weigh against the ordering of a new trial. So another one again in the column against a new trial. Now, there was the issue as well of the ordeal to be faced by the appellants if a new trial is ordered. And the issues raised here include the prison conditions, psychological impact on the men of being in prison so long, and significantly Kartel's physical health because he has Graves' disease and his heart was being affected. And the court said after such a lengthy delay between the commission of the offense and a possible new trial, the appellants would be once again faced with the ordeal of having to go through the trial process again and possibly 2 further appeals to the Court of Appeal and the Privy Council. And in the case of Kartel, Palmer, he would have to face a new trial with failing health while undergoing intense medical treatment. They said the hardship on him cannot be downplayed. They said in weighing this fact of the ordeal of a new trial on the appellants, on balance, it weighs more heavily against a new trial than in favor of a new trial. So another one in the column against a new trial. Those factors stacking up, not true. So what did the court say about the other factors? Well, in part 2, in my next video, I'll look at what they said about publicity, the actions of the prosecutions, as well as delay. Thank you so much for watching. I'm Dionne. I'll see you next time.